Welcome to the Animal Law Podcast. This is Marianne Sullivan. Today I'm going to be speaking with Tony Ellis-Susan of the Animal Legal Defense Fund, and we're going to be talking about the wall. And if you're like me, then you're going to know a lot more about the wall and what's going on after hearing this conversation than before, and a lot more about the efforts on behalf of animals to apply all of these laws, like the Endangered Species Act and other environmental laws, to the questions about whether, how, and where it can be built. This conversation really blew my mind, and really I realized how uninformed I was about how lawless this whole project really is. Well, before we get to that, I'd just like to quickly ask for your support to help us keep our hen house, which produces this podcast, the Animal Law Podcast, as well as the Our Hen House podcast. And if you can help out, please go to ourhenhouse.org/donate. There you can join our special band of supporters, whom we call our flock. You can make whatever donation you can afford and are comfortable with. If you can't manage to join the flock, we'd appreciate anything that you can manage. We'd really appreciate it if you can do something. The only way to keep this podcast and other animal-friendly indie media going is through supporting its efforts. And now to Tony Ellis-Susan. Tony is a cool guy. He fairly recently changed his career in midstream to work for animals and for the Animal Legal Defense Fund. And we are so happy that he did, because he was a superstar. He was with a major law firm. He had been named a national Law360 Rising Star, an Illinois super lawyer for 3 years running, and all sorts of other great stuff. And now he is working for the animals. And today, yes, we'll be talking about the wall. And of course, by the wall, I mean the proposed and proceeding border wall between the U.S. and Mexico. And we're going to be talking about what it will do to animals and how it's going forward in a way that just overrides every environmental protection law that has been built up over the years. And there are actually several cases currently ongoing. We'll be talking about them. They're very similar. They just involve different projects. One of which is actually pending a decision on a petition for a writ of certiorari in the Supreme Court. And this case is going to shock you, not only for the facts, but for the incredible exceptions that have been made to the laws. So listen up. Welcome to the Animal Law Podcast, Tony.
Thank you. Thank you for having me on, Marianne.
It is a pleasure to have you on, even though it has made me need to delve into this very complicated case, which I'm not sure I have all straight, but I know I'm going to have it straight by the time we're finished with this. And it's so important, and it is really just going through some of these papers has educated me about things that I should have known more about. So I know we have several lawsuits, and one of which was consolidated from a number of lawsuits, and we have to untangle some procedural stuff. But before we do all of that, let's just start with the basic facts underlying these lawsuits. We've all heard about the wall, but I don't know enough about it, and I don't know enough about what it's likely to do to wildlife. So can you just bring us up to speed on that?
Yeah, so there's been, various border wall constructions going back for about 20 years now. The current projects that are part of our lawsuits involve 5 segments or 5 waivers. There's 2 in California. One is along a 14-mile stretch in San Diego. The second is in an area that's a couple hours east in Calexico. It's about a 3-mile stretch. There's also a segment. It's right across the border from El Paso, Texas, but in New Mexico, in the Santa Teresa area, and that's about a 20-mile stretch. And then just within the last couple weeks, there were a couple waivers, and perhaps most troubling waivers in Texas, in Hidalgo and Cameron County, in the southern portion of Texas. And the current projects are sort of, some of them are ongoing. There was, for example, one of the California waivers related to a prototype project, and that has been completed. But like the construction in the Texas portions has not started yet.
And why is this a concern for animals? What kind of things happen to animals when these walls are built?
Yeah, it's really devastating. And these are areas of really intense biodiversity. There's been various studies of the U.S.-Mexico border region, but there's, approximately 100 endangered, threatened, or potentially endangered and threatened species that call these border areas their home. And many of them are migratory. And so they're their survival depends on their ability to sort of migrate, both through Mexico and the U.S. freely. And some of the, the species, even, the bird flying species, are low flying species, and they're directly impacted by a border wall. And certainly the mammals, that are ground based, if you were to construct this complete barrier, they'd be cut off. And so you'd literally be separating animal families from each other, which would affect, their biodiversity, their ability to mate and breed. And, when you're dealing with endangered or critically endangered species, that very well may be the tipping point that causes extinction.
So if I understand correctly, these cases have been brought by different advocacy groups regarding different, it's not all about animals, regarding different harms that would potentially be caused by the wall. Can you explain your claims, specifically ALDF's claims, regarding what federal statutes would be violated by these projects? Is this all the Endangered Species Act, or are there other animal-related statutes as well?
It's literally every environmental protection or animal protection statute that exists. And you're right, we're joined by environmental groups as well, because there'd be, devastating environmental impacts even beyond, just animals. But it's the Endangered Species Act, the Migratory Bird Act, literally every federal law that would protect endangered or any sort of species that might be in the area has been waived by the Secretary of the Department of Homeland Security. So we really will have wide-ranging, severe environmental impacts and impacts on humans too. I mean, the laws that are waived, it's dozens of laws. It includes the Clean Water Act, for example. So when they're constructing these walls, they don't have to be concerned about whether they're polluting, drinking water supplies for humans even. So it's really a terrible, terrible situation. So,
and before we get to the specific law at issue here, which does involve how these waivers have been imposed, I just want to, you mentioned that there were all these different projects, but there are actually 3 cases in different stages. And can you just explain where each of them are procedurally? Because one of them has gone pretty far, but the other 2, I think, are in the pretty beginning stages.
Yep, exactly. So the first waivers occurred in California, and a coalition of groups. There's actually 3 lawsuits filed in California that were ultimately consolidated. We were joined in that lawsuit initially with Defenders of Wildlife and Sierra Club. Center for Biological Diversity filed their own suit, and then the state of California, on behalf of certain agencies of California, filed a third suit. That was the first case, and it was in the Southern District of California before Judge Curiel. The parties filed cross motions for summary judgments, and the judge unfortunately issued a ruling granting summary judgment to the government. Without getting into the claims, it gets a little complex here, but one of the issues with the statute that we're dealing with is it attempts to insulate judicial review of the Secretary's actions. And one of the ways it tries to do that is by limiting the appellate path to only a petition for writ of certiorari to the Supreme Court. We had
I definitely want to get into that a little bit more in depth, because that's totally insane. But just give us the quick version at the moment.
Yeah. So the quick version is, because of that sort of wrinkle in the statute, we filed 2 appeals. We argued that under one of our claims that we had the right to still go to the Ninth Circuit. So we filed an appeal at the Ninth Circuit. And then as to the constitutional claims, based on this statutory provision, we filed a petition for writ of certiorari to the Supreme Court. The appeal in the Ninth Circuit has been fully briefed and argued, but we haven't received a decision yet. The petition for writ of certiorari, the government's response is actually due in the next week. And then in the sort of the next waiver was in the New Mexico waiver. We filed that lawsuit in the District of Columbia District Court. That has been fully briefed on cross summary judgment motions again, and there's an argument date set for December 18th. And then the very most recent waivers in Texas, which there are 2 waivers, we just filed suit earlier in October with Center for Biological Diversity and Defenders of Wildlife, and that lawsuit is again in the District of Columbia District Court, and it's just starting.
And do all these lawsuits involve essentially the same legal issues?
They do. There's sort of some statutory type arguments, and then there's constitutional claims as well.
Okay, I just wanted to make sure I wasn't, because I read more about the first lawsuit than about the next 2, and I wanted to make sure that there wasn't a whole new set of arguments. All right, so let's get into this Section 102 of the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, which is where these waivers come from that you've been alluding to. And as far as I can figure, this statute provides rules for border walls, unless I'm wrong. So first, tell us about the geographical limits that are set forth for border walls in Section 102B of the statute.
Yeah, so it's a mouthful, the statute, but so we usually call it Section 102 just to shorten it. It has sort of a tortured history, and I think going through quickly sort of the history of the amendments is helpful to sort of understand where this comes from. I mean, it's the Act of 1996, so it was enacted as part of an anti-immigration push in the 90s, and it was a very, very limited act when it was first enacted. It gave the Attorney General the authority to build a specific 14-mile stretch of reinforced fence near San Diego because there was this, I think it was called like Drug Alley. There was a specific area in the border where there was a significant amount of drug trafficking in San Diego, and that's what this act was designed to do. And then initially it was the Attorney General, but after 9/11, the Homeland Security Act transferred authority for control of the borders to the Department of Homeland Security. So there was an amendment that just sort of transferred that power to the Department of Homeland Security. But now, nearly 10 years later, in 2005, that very specific 14-mile fence hadn't been completed yet. And so in the Real ID Act of 2005, Congress expanded the authority of now the Department of Homeland Security to waive laws. And initially, there was only authority to waive the National Environmental Policy Act and the Endangered Species Act. But in the 2005 Act, Congress said that the Secretary of Department of Homeland Security had authority to waive any and all laws that she thought would, speed up the ability to build the wall. So it significantly expanded this waiver authority. And then it also, as part of the 2005 amendment, and then there was also an amendment in 2006 and 2008, Congress, through Section 102B, gave, instead of just this 14-mile segment in San Diego, specifically authorized the Secretary to build some additional fencing. So there is, for example, an 850-mile stretch of border that was a priority area under the 2006 Act. And then in the 2008 amendment, Congress dictated that the Secretary build not less than 700 miles of border in a certain, on the southwest border between U.S. and Mexico. And those were given, sort of priority. And that was the purpose for this waiver authority, was to sort of, carry out these specific projects that Congress envisioned in 102B. The waivers we're dealing with now, though, are the first waivers where the Department of Homeland Security is resting on sort of her general authority under Section 102A, which just says, that the Department of Homeland Security should secure the southern border. And that sort of differentiates these waivers from the prior waivers where they were specifically cabined to specific projects. Now the government's arguing it has essentially unfettered authority to build any walls it wants to build.
Yeah, this is give them an inch and they'll take a mile is definitely the phrase that comes to mind here. It started with 14 miles and now it's the entire border that they are claiming is covered by the statute. So, yeah, tell us about these orders. They were issued by the president and then I guess refined by the Secretary of Homeland Security that precipitated all the events here.
Exactly. And that's another really important distinction. The other projects were all driven by Congress. It was Congress saying, hey, Department of Homeland Security, which is a part of the executive branch, we want you to build these barriers. This is the first time where it's not being driven by Congress. It's being driven by, President Trump and his campaign rhetoric, which led into one of his very first acts upon taking office was to issue an executive order that specifically directed the Department of Homeland Security to secure the southern border, using whatever means available. And so based on that executive order, the Secretary of Department of Homeland Security, and actually just given the circumstances of the musical chairs in the Trump administration, we've dealt with 3 different secretaries of the Department of Homeland Security amongst these 5 waivers. But these 3 different secretaries or acting secretaries of the Department of Homeland Security have exercised this waiver authority for the first time in sort of an uncabined, unfettered, discretionary manner to dictate different projects that were not specifically mandated by Congress.
So the statute talks about a waiver, how broad is this waiver? They're waiving all of these laws that would otherwise apply and just saying that they don't apply in this instance. And how broad were they before, and how broad is this new one?
The 5 that we're dealing with are the broadest of the waivers. Some of the historical ones in 2006 and 2008, covered dozens of laws, but these are covering all the laws that were waived before, plus some additional laws. And under the statute, the government's position is that it's completely unlimited. So the secretary waives, dozens of federal laws, all state law, all local laws. So there's issues of federalism in our case because, it's really, a complete usurpation of all local, state, and federal laws in these areas. And specifically with regard to federal laws, each of these waivers contains a list of dozens of federal laws that are being waived. And it's the most significant environmental and animal protection laws, the Clean Water Act, the National Environmental Policy Act, the Endangered Species Act, the Migratory Bird Act. But it's also things that you wouldn't even think would be implicated by some of this construction and statutes, frankly, that I had never heard of. For example, there's like a Paleontology Act that I think is supposed to protect dinosaur bones. And the secretary is waiving those, even though I think in some of these cases there's really no evidence that there would be, sort of dinosaur bones in the area, which just goes to show that, that there's really, not a lot of, specific reasoning going on in these waivers. It's just, let's waive anything that could possibly lead to litigation that might slow us down.
And is there any limitation on when or how the secretary can institute these waivers, just aside from the fact that a border wall is being built?
No, that's one of the significant problems. The government's position is it's completely unfettered and solely within the discretion of the secretary, and that furthermore, other than constitutional claims, it's not even subject to judicial review. And one of the problems with the statute is, it's dealing with border wall projects, but there's not really any specific language in there that tethers the secretary to waivers within the border region. So, for example, you could see a scenario where the secretary, since she has complete and unfettered discretion, thinks that in order to expedite border wall construction, maybe she needs to build a new manufacturing plant. And so she waives laws to allow the building of a manufacturing plant that's not really in the border area. I mean, under the government's view of the statute, I think they would take the position that that's allowed.
This is really insane.
It is.
It really is. Like, it's so complicated that it's easy to gloss over it, and then when you get into the details, it's like, oh my God, this is just crazy. All right, sorry. Sorry for the editorial in the middle of this interview. All right, let's get to the cases. We haven't even gotten to the cases yet. Each of them started out in district court. 2 of them are still in district court. And the one that was decided against you. And my understanding is that your claims can be broken into 2 basic overarching arguments. One is that these actions were not authorized, but actually weren't authorized by the statute, that these waivers are not legitimate under the statute. And the second is that even if they were, the statute is unconstitutional. Is that right?
Exactly. And I look at it as sort of 2 sides of the same coin. I mean, either the government can't have it both ways. Either the statute has to have some limitation to it, which if it does, these waivers clearly exceed that limitation. Or if it's truly boundless, then it violates, various constitutional provisions.
Oh, yeah, that makes a lot of sense. So let's start with the basis for your claims that the actions were ultra vires, and weren't authorized by the statute. What are your basic arguments here?
Yeah, so under the ultra vires argument, essentially it's, the way I frame it is it's really an inherent authority of the judiciary to determine whether an administrative agency has exceeded its statutory delegation of authority. And the standard that's been articulated is there a clear statutory mandate? And if there is, did the agency act in excess of that statutory mandate? And then if so, will that action that exceeds the statutory mandate somehow impair statutory rights of the party that's suing? And here, it's clear to me that these waivers do exceed the statutory mandate because, like I said, all the prior waivers, and if you look at the history of the statute in the context of all these provisions, they were being driven by Congress, and Congress was only giving this extraordinary waiver authority to the Secretary of the Department of Homeland Security to complete very specific projects and priority areas that Congress had dictated be built. Here, that's not happening. It's the secretary on her own, via the executive order from the Trump administration, deciding what she wants to build, not being driven by Congress. It's being completely unilaterally driven by the Department of Homeland Security, and there's simply nothing in the text of the statute that would authorize this sort of general, non-Congress driven, non-legislative driven action. And so that's essentially the core of our argument that it's exceeding the statutory mandate.
Is there also an argument that the prior uses of this statute were kind of within the confines of 102B, which sets forth the kind, I'm calling them geographical limitations, but that this just goes beyond what Congress anticipated in where a wall could be built, similar to the argument you would make in the example you gave, like what if they were building a factory somewhere to facilitate these actions? Can you argue that it's not just procedurally, but it's actually not within the confines of the geographical limitations set forth in the statute?
Yeah, that's exactly right. So the prior projects that Congress dictated, when they dictated them, they put them in Section 102, subsection B. And that's where the priority areas were. And that's where, sort of even that initial 14-mile fence was. These are the very first waivers where the secretary is relying on the general Section 102A authority, which if it's a very convoluted statute. It's actually not even codified in the actual statutory text. It's codified in the notes to a statute, which I've never seen before.
Yeah, that's totally bizarre.
It's very bizarre. It's just the whole it's very bizarre. But if you look at 102A, to me, that's just sort of a general statement of principle. It's just saying, we're creating this law in order to allow initially the Attorney General, but now the Department of Homeland Security to build, border walls to secure the borderlands. And then in Section 102B, that's where there's very specific projects, the priority areas, the 14-mile stretch. Mm-hmm. And then Section 102C is where the waiver authority and the judicial limitation provision exists. And it's clear to me that 102C was designed to allow the secretary to carry out what was set forth in 102B. And here we're dealing with, 102A projects. So I think you're right that when you look at that structure of the statutory scheme, that's another reason why it's clear that the secretary is exceeding what was really intended by this 102C waiver authority. And
then, of course, your other arguments are that assuming that this is the right interpretation of the statute, that the statute has to be unconstitutional. I think there are three basic reasons for your unconstitutionality argument. Can we go through them? Maybe starting with this separation of powers and non-delegation argument?
Exactly. They sort of all flow from a general sort of separation from powers basis, and the non-delegation argument in the petition for writ of certiorari, that's our primary argument. The non-delegation doctrine, it was last used affirmatively to strike down a law in the 1930s, and it's been raised in recent years but rejected in different contexts by the Supreme Court. But basically the non-delegation doctrine says that when you're dealing with a legislative congressional function, the Congress can delegate that authority to the executive agency through administrative agencies, or to the executive branch through administrative agencies. But if it's going to do that, it can't completely delegate its legislative authority. It has to provide some sort of guidelines. Usually the courts refer to it as an intelligible principle to sort of guide the agency or the Secretary of Department of Homeland Security's, exercise of this legislative function. And in all the cases where the non-delegation doctrine has failed, there's been very clear standards given by Congress. So, for example, there was a Clean Air Act challenge recently in the Supreme Court that was upheld, and it was upheld because when Congress gave power to the EPA, it gave certain guidelines as to what the EPA should look to in regulating clean air, to ensure public safety. It should look at certain technical documents. It should look at, criteria about what standard of pollution would, impair the public health. And that's how that discretion should be exercised. Here, under the government's own view, there's literally no limitation given to the secretary. She has unfettered and exclusive discretion to waive whatever law she wants to build border walls. So this is a very, very different circumstance. And we think that, like I said, it's sort of two sides of the same coin. Either there is some sort of statutory limitation on the secretary's exercise of her waiver authority, in which case she's exceeded it here, or if it's truly unbridled, like the government argues, well, then it has to be a non-delegation problem, or otherwise there'd be no check whatsoever on the secretary's authority.
Yeah, as you point out in the papers, she would actually have the power to waive laws, I mean, such as the laws you're talking about, the Endangered Species Act and all of these other laws, about which her agency has no expertise. I mean, what's the point of having agencies that do have expertise if you're going to allow the Department of Homeland Security to just eliminate their laws whenever they want to?
Exactly. And it also, it's not only waiving laws that are regulated by other agencies, it's also waiving laws that specifically are supposed to check the secretary's own exercise of power. So she's waiving laws in order to give herself more power, essentially, which there's not another case like that out there. And that definitely makes the delegation here much more egregious. Yeah,
actually, there was a quote from Congressman Blumenauer that you quoted, I think, in your papers, and I loved it. I guess it was when the statute first passed that this provision meant that the secretary could build a border barrier by giving, quote, a contract to his political cronies that had no safety standards, using 12-year-old illegal immigrants to do the labor, run it through the side of a Native American burial ground, kill bald eagles in the process, and pollute the drinking water of neighboring communities. And there would be nothing to stop them.
Exactly.
All of the laws that we have passed to prevent any of those things could just be waived.
Exactly. And if you look at the list of laws that were waived here, it very much would allow that exact scenario to happen.
And though this is the Department of Homeland Security, there's no necessity for a finding that there is or is there? Am I wrong that there's a finding that there's an acute national security interest at issue?
Yeah, so all that the secretary has to make a determination of is that it's an area of high illegal entry and that building the border walls is necessary to combat that. And then it will have some, helpful impact on securing the border wall. But that's solely a determination that she makes in her discretion. The government has taken the position that they really don't need to justify that with statistics or any sort of fact finding. The secretary, it's just solely within the discretion of the secretary to make that finding.
And also, I mean, not to get into but you don't have to be an open borders person to think that that's extreme. That's not, I mean, crossing the border is not necessarily an issue of dire national security. But anyway, let's not get into that because that's a road we don't need to go down at the moment. You have two other constitutional arguments, and you mentioned that they were all related, but I'm really not that familiar with these clauses. So can you just go through your presentment clause argument and your take care clause argument?
Yeah, so the presentment clause is sort of the other side of the same coin to the non-delegation doctrine, which it argues that under the presentment clause, the way that legislation is supposed to be enacted is, Congress passes it, it goes to the president signs it into law. There was a successful presentment clause challenge to the Line Item Veto Act under the Clinton administration. And essentially the theory was there that you were allowing a legislative function to go to the executive, that he would, he in that case or any future president would have the power to repeal laws at their sole discretion. And that, sort of undermine the very foundation of the constitutional presentment system as to how laws are supposed to be enacted. And so it's sort of a similar situation here. In fact, you could argue it's a greater violation of the presentment clause here because under the Line Item Veto Act, which was struck down as a violation of the presentment clause, there were certain checks. For example, there was only 3 types of laws that the president could use the line item veto on. If the president used the line item veto, he or she would have to issue written findings to Congress as to why the line item veto power was used, and then Congress would have the ability to override or disagree with the line item veto, which that decision would be subject to the constitutional veto, the veto power of the executive, but there was still sort of a check there. Here, those limitations don't even exist. You've essentially given unfettered, it's any law, any federal law, any state law, any local law that the Secretary of the Department of Homeland Security thinks in her sole discretion might possibly impede the construction of a border wall. She has complete power to waive, according to the government. So it's a much broader problem than the Line Item Veto Act.
And the take care clause, is that basically the same issue?
It's similar. It's sort of another, based on sort of the way that the constitutional system was created. I mean, the one interesting thing about the take care clause is it's not a constitutional provision that's been used very often in litigation, so it's a little bit novel. Because of that, maybe it'll be something that the Supreme Court will be interested because they really haven't had a chance to weigh into that area. But essentially, there's a provision in the Constitution that says that the executive must take care to exercise or execute the laws faithfully. And the argument is, by invalidating all these laws, you're not executing the laws faithfully. You're actually contravening them. So it's an interesting sort of novel argument, and it'll be interesting to see if it gets the Supreme Court's interest.
Yes, one thing this current era has given us is some interesting and novel constitutional arguments. So here's another one. I had never heard of the emoluments clause until the Trump administration either. So there's all these clauses that we have to become familiar with. All right, so what happened in the district court? I mean, we know you lost. So can you just give us the highlights of how the court disagreed with your arguments?
Yeah, so I Judge Curiel is a very, very good federal judge. I obviously disagree with the way he resolved this case, but he did a great job in analyzing the issues. I think it was like a 100-page written opinion, and it was based on an extensive oral argument and very, very extensive briefing. At the end of the day, on the ultra vires argument, because the statute is such a mess, I think that's really where he came down on it. That because from his perspective, the statute was so convoluted, the government had a plausible argument that it really was, in fact, this completely unlimited waiver of, this completely unlimited authority to waive any and all laws. And because the standard for the ultra vires claim is that we have to show that a clear statutory mandate was violated, if the government's interpretation is plausible, we sort of fail on that factor. So I think that's really was a critical issue on the ultra vires claim. And then on the constitutional claims, there had been a series of cases in the mid-2000s that dealt with some of these constitutional issues. And he basically sort of followed the reasoning of those cases. The non-delegation doctrine, as I mentioned before, it's a doctrine that hasn't been affirmatively used to invalidate a statute since the 1930s. So you could sort of understand in that context why a district court might be a little bit hesitant to find the statute violated the non-delegation clause. And he essentially said that because, the nature of the statute related to border wall projects, and the waivers were for border wall construction, that was sufficiently, cabined the secretary's discretion to avoid a non-delegation problem, which I think that's just wrong when you look at the government's position that this is truly like an unfettered and judicially, insulated process. That's essentially, how we resolve the case. I think knowing that, we were going to be filing a petition to the Supreme Court so that, if there were merit to the non-delegation doctrine, maybe it's more appropriate for the Supreme Court to reach that decision first.
Yeah, let's talk about that, because you alluded before to this bizarre appellate procedural thing in this statute. And can you just go into that a little bit more of why you are in both the Ninth Circuit and the Supreme Court at the same time appealing this case?
Yeah, so, when the law was first enacted in 96, the Congress wanted this 14-mile stretch built, and it still hadn't been built by 2005. And one of the reasons why it hadn't been built is there was environmental litigation going on. And so a Republican Congress at that time created this judicial provision, expanded the waiver authority so that the secretary could waive the very laws that were at issue in these lawsuits in the 2005 time period. And also, I view it as sort of an anti-Ninth Circuit provision. They also cut off any appellate review other than a petition for writ of certiorari to the Supreme Court. It also limits any claims to constitutional claims on its face. The statute says you can only bring constitutional challenges. You have to bring any challenges within 60 days of the invocation of the waiver. So there's a very, very short time period to file a lawsuit. And then it vests exclusive jurisdiction in the district courts, federal courts. So it arguably removes any concurrent jurisdiction that the state courts might have. which is significant because the waiver includes state and local laws, and one of the plaintiffs was the state of California, which clearly, might have an interest in litigating some of these issues in the state courts of California. But that's the judicial sort of limitation within the statute. Our ultra vires argument, because it's based on the concept that the secretary exceeded her statutory authority, sort of, side to side with that is, if the secretary has really exceeded her statutory authority, then that claim shouldn't be limited by this statutory judicial limitation provision. And the district court actually agreed with us on that. He did conclude that he had jurisdiction to consider the statutory non-constitutional claim, even though the statute on its face is limited to constitutional challenges. And because of that, we then viewed our appellate path to the Ninth Circuit. And we haven't heard from the Ninth Circuit on whether they agree with us on that. But as to the constitutional claims, given the constitutional claims, do fall under the statute itself, then the only route was a petition for writ of certiorari to the Supreme Court, which we have pending.
That I just can't even imagine the circuit. Well, I can't imagine a lot, but the circuit going the other way on whether your ultra vires claim is barred by, or appeal of your ultra vires claim is barred by this provision. Like, otherwise they could do anything under this statute, and just be entitled to appeal directly to the Supreme Court. That's crazy. This is all crazy, Tony.
It is, and the government's argument is really, I view it as absurd, because their argument is that Congress clearly and unequivocally wanted to preclude judicial review of actions that exceeded what Congress intended to have happen. In other words, from the government's perspective, Congress is saying, you know what, Secretary of Department of Homeland Security, you do whatever you want. And even if you do something we don't want you to do, even you do something that goes way beyond what we ever intended, we don't think the judiciary should weigh in and stop you from doing that. I mean, that's just unbelievable. I mean, what kind of world do we live in if that was allowed to happen? The whole purpose of our constitutional system is to have checks and balances. And there's no reason why Congress would want to completely eliminate, a judicial check on action that's specifically inconsistent with what Congress intended. But that's the government's argument.
Yeah, wow. These are crazy times. That is a crazy argument. So that's where we are, and we'll all be waiting to hear an outcome. I think you told me before we got on the interview that you just had a development in the certiorari petition with California. Is that right?
We did, yeah. When we filed our petition for writ of certiorari, it was the Animal Legal Defense Fund, Defenders of Wildlife, and Center for Biological Diversity decided to join the petition. Initially, the state of California did not file their own petition or join our petition, and it was unclear, whether they were going to participate at the Supreme Court level. And there's a little bit of inside baseball there, but they just, I think it was yesterday, the Attorney General for the state of California sent a letter into the Supreme Court saying that, as is their right, because they're a party to the proceedings below, even though they didn't join the petition, if the Supreme Court were to grant certiorari and hear the case on the merits, California said they would participate in the merits briefing, which is a really significant development because I'm not a Supreme Court practitioner, but the Supreme Court practitioners and clerks will tell you when you have a state as part of the petition, they call it a state on top petition because it involves a state, that just gets an extra level of consideration by the court, and the court will take it much more seriously. So I view that as increasing our chances of getting a grant in a very helpful way.
Well, I certainly hope you do. There's a lot pending here. We'll be looking forward to hearing more about what happens in these cases, and hoping that the other cases one of which you just filed, the other which you filed not too long ago. I guess that the second one has already been briefed for summary judgment.
It is, and we have an argument set for December 18th in the District of Columbia District Court.
So we'll be looking forward to hearing what happens in all of these. This is crazy. Is there anything, it is a convoluted case, and I'm not sure I'm up to speed on everything. Is there anything I should have asked you that I didn't?
No, we've covered everything. This has been a really great interview.
I think so, too. I think your part was good. Well, or Mutual Admiration Society. And
That's right.
But it was really helpful to me. I understand the case much, much better than I did before I started talking to you. So that's really helpful. And I'm deeply more horrified. So that's helpful, too. as if we can't be horrified enough these days. Thanks so much for explaining it with such clarity, Tony.
Well, thank you very much, Marianne.
We'll be looking forward to hearing what happens. Thanks so much for joining us on the Animal Law Podcast. We'll be back next month with a new show. Thank you so much to Tony Ellis-Susan for taking the time to explain these cases to us. And thank you to Michael Herron and John Frusciante for their help in producing this podcast. And if you like what you hear, please subscribe on Apple Podcasts or on your favorite podcatcher. Consider leaving us a good review on Apple Podcasts. And of course, if you are able, please consider making a tax-deductible donation at ourhenhouse.org/donate. Thanks so much for tuning in.